started.
Hello, everyone. Andre. I'm the Executive Director of the Tax Review Board, and we're convening our meeting for today. Today is Thursday, May 26th. It is approximately 2:07. Please be aware that this is a public hearing, and it is being recorded because the meeting is public. Because the meeting is public, participants and viewers have no expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. At this time, I'm going to pass the physical mic to our chair, Nancy Cameron.
Good afternoon, everyone. As has been indicated, this is the beginning of the Tax Review Board hearing for May 26th, 2022. The first item we're going to deal with is one that was held under advisement after an earlier hearing. And I believe we have someone representing the petitioner who is with us today to hear this result. Is that correct? And if so, would you identify yourself for the record?
Yes, hi, good afternoon. Lorenzo Di Natale, attorney for petitioner.
Okay, thank you. In this matter, which was for Philadelphia Lotus 6 LLC, the board had asked for briefs from both parties. Those briefs were provided and reviewed by the board, and it was our determination that first, the right of redemption does not apply in this matter. And secondly, that a notice to the petitioner was insufficient due to administrative failure to record the deed in a timely manner. As a result, we decided that we would abate 1/2 of the principal and abate 100% of the interest and ask for payment arrangements to be made within 30 days. I would like the board members who are present on the Zoom call to indicate whether or not they concur in that decision.
George Matthews, I concur.
George Matthew, okay, you're going in a different order than I was starting out. Paula Weiss, you're muted.
Sorry, Paula Weiss, I concur.
And Dominic Ward?
Dominic Ward, I concur.
And Nancy Cameron, I concur.
My apologies. Can I just get that one more time? It was half the principal and what was the interest?
100% of the interest. And payment arrangements within 30 days.
And I'm sorry, for clarification, may I have the exact numbers that we're dealing with so there's no confusion?
At this time, the board doesn't really give out numbers. The decision will be applied by license and inspection to the department, and a bill will be sent to your client. Because interest, as you know, and we don't touch the bill. Okay, Mr. Dillon?
Okay.
Thank you very much for coming in.
The appeal rights.
This I was forgetting. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. I'm going to assume for the moment that neither side is going to choose to appeal, and if that proves to be the case, then we would ask that arrangements be made to implement the decision with the payment that would come due. You would at that point be getting a letter from the city that spells out all the details that you're asking about.
Understood. Thank you.
Thank you very much. Sorry about leaving out that very important portion.
Okay. Mr. Di Natale, your client was ready, because I didn't see them in the room when I put you in there.
Not yet. I'm going to go over the paperwork that was just provided and discuss it with her. Okay. I think there's another party here.
Yes, we'll go with case number 2 at this time.
Thank you.
I'm going to put the other person in.
Okay. Case number 2 is from Rojmanda Zepaj, and I apologize if I've been pronouncing that incorrectly. The docket number ending in 9361, and the property address is for 5939 Chestnut Street.
Coming here?
Your voice,
Yep.
Okay, good. Thank you. If you would, please identify yourselves for the record.
Good afternoon. My name is Thomas Barnes, law office of Joseph Kelly on behalf of Nicholas. I'm gonna butcher this. Erasmus.
I'm having trouble.
Erasmus. There you go. Erasmus.
I was getting a lot of feedback. I was having trouble understanding what you were saying. Is one of you an attorney and one?
Yes.
Okay, you're the attorney. Okay. And then if the other person who was there would identify himself for the record.
Yes, I am Nicolas Erasmus.
And do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
For clarification, this is cases 3 and 4, correct?
No, this is case number 2, 5939 Chestnut Street.
No, this is 1439 South 8th Street.
Oh, I'm sorry. This is 3 and 4. I apologize.
Oh, okay. Then I introduced the wrong account entirely before you came into the room. And that's probably my error here. So the case before us is Nicholas Aratzers, and I may have butchered that. My apologies if I did. Dockets ending in 6735 and 6741 for, as has been indicated, 1439 South 8th Street. My apologies. I had them in the wrong order. We had it correct in our handwritten agenda. Who has this matter for the city? If someone's answering, you must be mute. Does anyone have cases 3 and 4 from the law department? We've got quite a few lawyers on. Isn't anyone responsible?
I'm sorry, board. Can you repeat this address one more time?
1439 South 8th Street.
We just asked the board's indulgence. We're gonna look into this.
Okay, yeah, it's cases 3 and 4 on today's agenda.
Counsel for petitioner, have you spoken with anybody from the city on this matter?
No one from the city has reached out to us after we filed the appeal, so we have not spoken to anyone.
Okay.
I mean, the only communication with the city would be my client's homeowner insurance forwarded the city a check in the amount of.
We shouldn't be going over details on the case until we get the appropriate parties lined up.
Okay. Well,
Ms. Davis, how are we doing here?
I'm gonna get in contact with the assigned attorney at this moment. If I could just have like another brief 2 minutes.
We have a full agenda. Do we want to move on and come back to these?
Yes, Paula. At this time, Nancy, can you read in the continuance request for case number 5?
Okay, we do have the details. Okay. Just before today's hearing began, we got a request from Michael Tierney regarding case number 5 on the agenda, docket ending in 6790 for 624 Summit Avenue. He has followed that request that was an oral request up in writing and has indicated that he needs a continuance and was unable to come into here and couldn't follow it with the kinds of devices he had. So as a result, we need to have a vote from the board about whether or not we would grant this continuance request.
Members of the board, good afternoon. This is Jeffrey Cohen for the city of Philadelphia. This is actually my matter.
Which one is your matter? This one from
number 5,
Mr.
Mr. Tierney.
Okay.
Has Mr. Tierney explained his standing in this matter? As the city indicated in its position statement, he is not the record owner of the property and would thus need to explain what his interest is in this matter.
No.
The bill at issue was issued to Francis Tierney, not to Michael Tierney.
He is not, but perhaps we we can figure that out at the next listing.
Mr. Cohen, have you spoken to Mr. Tierney?
No, not on this matter.
Well, maybe before the next listing, a conversation could happen.
Right. But-
Is this the first request for continuance?
Yes,
Yes.
before the board.
And so do the board members agree to granting the continuance?
Dominic Ward concurs with granting the continuance.
Paula Weiss, I concur.
Ryan Boyer, I concur. I just got on.
Oh, thank you.
Hi, Ryan.
George
Hello.
Matthews, I concur.
Okay, and I concur as well. So the entire board concurs in this, and we will hold it aside for a listing on a future hearing date. And in the meantime, if the city can and has an opportunity to make contact with them, perhaps this matter could be resolved even without a hearing. If that proves to be the case, please let us know so that we don't schedule.
Chris Johnson is
course.
signing on for the city for cases 3 and 4.
Yes, I just let him into the room. Thank you,
Okay.
Dominique. Mr. Cohen, do you need his number, Mr. Tierney's number to contact him?
Is it on his paperwork, the petition that he filed? Then I already have that. Thank you.
Mr. Johnson? We're going back to cases 3 and 4.
And please, you're on mute. If you would identify yourself for the record. Mr. Johnson?
Hi, this is Christopher Johnson for the city of Philadelphia.
And we had introduced this case earlier, not realizing that you were not on the call. And so we have already introduced the matter in terms of the docket numbers and have sworn the petitioner. Do you have anyone who needs to be sworn from the city's end who would be participating but is not an attorney?
No, I don't. And I'm under the understanding that this is related to the gas explosion at 1437, 1439 South 8th Street.
That's the 1439 address is what has been given to us for the property address for both docket numbers that were identified.
Okay, and my apologies. I wasn't aware that was listed today, but I can tell you there's really, the city has agreed to rescind all the bills related to abatements from the gas explosion, and that has already been processed on the city's end, so there's no balance owing at this point in time.
Would that deal with both of the docket numbers that we have on today's agenda? Do you know?
Yes, it does.
Okay, returning to the petitioner, were you aware that this matter was being processed at the city's end? Had you heard anything about that before?
No, I had not.
So
Mr. Johnson, will the petitioners be getting documentation shortly from the city on this matter?
Yeah, and I apologize because I wasn't aware this was listed today. The city has agreed to rescind all the charges related to the abatement from the gas explosion, so there's all those cases are going to be moot.
Okay, but and they'll be getting notified though?
Yes.
Okay.
I guess my question is, should we be continuing these items until the documentation goes out and the petitioner can confirm that everything is cleared, and then notifying us that it should not be listed for another time?
What I can do is, if I submit documentation to the board and to all the petitioners at the same time, can the board resolve all those cases without rescheduling them?
Well, basically what we would need is concurrence that we need not go further on this matter because it has been resolved.
Or the petitioners actually need to then withdraw their petitions.
Exactly.
I would be more safe waiting until we got that paperwork saying that I was taken care of, just in case it pops up in the future.
Right, so I would say that we should continue this matter, and once the petitioners or all the homeowners, I guess, have received their documentations, that these bills are rescinded and now it's zero, they should be directed to withdraw their petitions before the tax review board because there's nothing to hear.
Okay.
Do all of the board members concur in continuing this matter?
Dominic Ward concurs.
Paula Weiss concurs.
George Matthews concur.
Ryan Boyer concurs.
And Nancy Cameron concurs.
Ms. Andre, can you just put all these cases off to the side so they don't get scheduled again?
Or, yes, I think that's what I'm gonna do, and I'm also
And
gonna
then
try to just touch base with Mr. Johnson, so that way if the bills come saying that there is, I can reach out to the petitioners and request that they provide withdrawal documentation.
Yeah, so you can know the addresses. You need to know the addresses. The city know them. You have no way of knowing them, all the houses that were affected. So you should work with the city to make sure.
Yes, so if Mr. Johnson, once it processes through the city, if you could send me all the addresses and let me know that you were told that they had filed here, then I'll know to reach out to them and then have them withdraw.
I have the list of the properties that are affected, and I can send it to you by tomorrow.
Thank you very much, Mr. Johnson.
Thank you.
Thank you. And in terms of the petitioners who are in the room here today, is there anything else that you need to know, or are you comfortable with going forward with what's already been discussed?
I'm comfortable, and once we get that paperwork, then we'll just withdraw what we filed.
Okay, well, thank you very much for coming in today, and we look forward to hearing that everything's been resolved after today's meeting.
Thank you. Have a good one.
Thank you.
Bye. Bye.
Thank you.
So at this time, I'm gonna go reach out to case number 2 and see if they're ready to proceed. It's 2, right? Yes, 2.
I know we've been back and forth so much, it's hard to know.
This is what I have. I mean, I'm not, now they're going I have a couple here. I think we might be good. We might be good. We could sit one more.
Okay, case number 2 is for, and please forgive me if I mispronounce this, Rojmanda Zapaj. Last 4 digits of the docket 9361. The property address is 5939 Chestnut Street. If the parties who are in the room would identify themselves for the record, please.
Good afternoon, Lorenzo Di Natale for the petitioner. And my name is Aurelio Jeppe. I'm on this.
And
My name is Raimonda Jeppe.
And for the 2 petitioners, do you swear or affirm to tell the truth with everything that comes before the board?
Yes,
I do.
Okay, thank you. Who has this matter for the city?
Desiree Davis on behalf of the city of Philadelphia.
Will you have anyone testifying with you who is not an attorney and may need to be sworn?
Yes, Inspector Robakowski.
Please identify yourself for the record.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you.
We also have Richard Wade from License and Inspection as well.
Okay, if you would identify yourself for the record.
Richard Wade, License and Inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. Do we have numbers for the record on this?
Yes, this is for the demolition at 5939 Chestnut Street. Bill date July 28th, 2017. Labor $14,428.93. Administrative charge $3,030.07. Interest $4,364.50. Total amount due $21,823.50.
Does the city have any opening comments before we turn to the petitioner?
Just briefly, board, this matter before you all is stemmed from the lack of due diligence presented by the petitioner regarding the property at 5939 Chestnut Street. What you will hear today is that this property was in an imminently dangerous condition that required immediate demolition upon the inspection from the Department of License and Inspection. And for that, in regards to that matter, the city is ready to proceed.
Okay, then let's turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
Thank you, and good afternoon all again. So what we're here for today is basically, my client has paid some taxes. We have a refund request in. She's only received one payment of the taxes she's paid on this property back. So, and I believe I provided that. Somebody should have a copy of it. The amount.
Mr. DiNatale, can we stop you a moment? What
Yeah.
tax are you talking about? We're
of
here.
property taxes.
All right, so we're here looking at L&I bills, a demolition bill?
Yes. Well,
Okay,
it's all part of it because, so essentially what happened was the property was demolished without notice to my client. And she was paying on an assessed value of the property that's supposed to have a building on it. But there is no building. So she made these payments and she only got one payment back instead of two.
so you're not questioning the demolition?
I'm sorry?
Are you questioning the demolition bill?
Well, we want that abated as well. And our reasoning behind that is that my client received no notice of the demolition.
Well, that's the only thing that we could talk about today is the actual no notice in the demolition bill because we have license and inspection. We don't have anyone from the revenue department of the city to fight that. So it's a real narrow scope that we're dealing with today. That's the L&I and the demolition on a property. So argue that.
Okay.
And I would ask that included in what you are discussing, there's an indication of when the property was acquired by the petitioner and the relationship in time of that and when there was or should have been notice going out for the demolition.
Sure. So what we have, and please let me know if you have these documents. I did submit them when I first came in. You should have my client's sheriff's deed. Do you have that?
I'm sending it right now. I'm sorry, I've been running around.
So while we're getting some of those documents, could you give us the chronology verbally, when it was purchased, sheriff's sale, when there was notice, when there was demolition, like what,
Sure.
keep in mind, we're starting from scratch here.
Sure. Can you please tell us when you purchased the property at sheriff's sale? Come on, Bill. Oh, yeah, it's, I mean, you can refer to, they have these documents. Go ahead.
The question, has she been sworn in? Have any of the witnesses for the petitioner been sworn in?
I believe so.
Okay, cool.
And but I need her to move a little closer to the microphone so we can
Right,
actually.
yeah, they were sworn in when they first were introduced.
And excuse me, board, I just want to clarify that we are beginning testimony, correct?
Yes,
Okay, thank you.
I'm also sending you what the petitioner gave me earlier, so look out for that in your email.
Thank you.
All right. So we have some notes here and I've submitted the notes for everybody's edification. This is, if you could see it, what my client is looking at and you have a copy of it.
We can't really see that.
We can speak it though. All right, yeah, that's fine, that's fine. All right, so please tell me, when did you purchase the
I bought the
property?
house in a sheriff's sale, 2/16/17.
Okay,
37,000 cash.
okay.
So after,
What was the date? I'm sorry, Mr. DiNatale, I'm having trouble hearing. What was the
The
date?
date of purchase was 2/16/17.
Thank you.
Okay,
I'm sorry,
all right. So the information on here is incorrect. Okay, so let's proceed now.
just the deed.
Right.
Natalie, can you please have the petitioner move closer to the microphone? She's way too far and no one can hear her.
Okay, so the sheriff's sale was, as petitioner stated, 2/16/17 for a price of $37,000. If we look at the sheriff's deed, which I have submitted to you, this is simply when it was recorded. There's a date on top of 3/17/2017. That's when it
I'm
was.
going to object. Is there a question that's being asked to the actual petitioner here?
Not right now. not right now. I mean, she wouldn't be able to point that out. So what was asked for was a chronology of events. So I'm simply doing that. If you want something different, I'll be happy to provide it.
No, please go ahead.
Okay. And you have a copy of this. This is when the sheriff's deed was reported. Oh, and by the way, let me ask you a question. When you purchased this property at sheriff's sale, was there any indication whatsoever that this property is unsafe? Can you shut that off, please? Was there any indication that this property was unsafe, of record, anything like that?
Nothing.
Okay. So you were never notified of an imminently dangerous condition, is that correct?
I never done.
Okay. So, at some point, you went to see the property.
Yes.
What did you find?
After we bought the house, we are supposed to go there.
Mhm.
So we went there to see it. Has a lot of work to do, but all around she was safe. Was not in danger.
Okay.
Like has been too many years empty. So I was trying to find some people to clean the house.
Okay.
The time I was cleaning the house, well, I finance my home to take the money to fix it, to fix the house. So I have been 2 or 3 times, 4 times. I never see any sign. I never see any surrounded, any dangers, nothing.
Okay.
So how do I know?
Okay.
Just the last minute, my husband was in the hospital. Maybe for 1 month, I didn't see it.
Okay. Did you ever receive anything in the mail telling you this is in a dangerous condition?
I never get any mail. I never get any notification.
Okay.
That's why I was so surprised.
Okay. Anything when the few times you did look at the property, were there any signs, any fences? Did you see anything around the property?
Nothing.
Okay. All right. So then at some point, the property is demolished, correct?
Yes. When I saw damage, I was so, I don't know how to explain.
Okay. And at that point, what, if anything, did you do?
The point, I went to the sheriff's cell.
Okay.
And I said, what happened to my home? I said, I just bought. And he said, you have completely right to complain because you bought, you recorded the deed. There has enough time to send you a notification. Don't send in prior notification before somebody has the property.
Okay. And I'm looking at
And he gave me some address.
okay, I'm looking at some paperwork. I guess we can mark that as P1 as well. It looks like some kind of general claim information form that you walked in and they filled out for your loss.
Yes.
The city, and it has a name of Paul
Yes.
Cosell. Okay, did you ever hear anything back from anybody?
Nothing.
Okay, so that's why we're here?
Yes.
Okay, and you feel that you shouldn't pay for the demolition today?
I don't feel it. I don't-
Because you were never notified?
Yes.
Okay, what, if anything, would you have done if you were notified?
Would
have pulled the permit? Hold on.
Objection.
She's testifying. Well, go ahead, please.
If I would do, I was gonna do an emergency, to put the license to fix the house.
Okay, so certainly if somebody notified, you would have taken action, is what you're saying?
Sure.
Okay, all right. So that's why essentially we're here.
We get a little, or maybe the city will do this, a little bit of chronology. She purchased this in February of 2017. About how much later than that date did you go and find that the property had been demolished?
After 2 weeks.
2 or 3 weeks, 2 weeks maybe,
2 weeks.
Okay. Thank
Because
you.
I went back to sheriff's cell, and they told me the day, and he said, you have a right to complain because you are in time. And he gave me address. I went everywhere.
Excuse me, did you say 2 weeks or 2 years?
2 weeks, 2 weeks.
Weeks. Okay, thank you.
And did you go, so you filed the claim with the sheriff's department or with the law department?
No, with a lawyer.
Mr.
You have a copy of it. It's with the city of Philadelphia. You should have a copy. I provided that as well.
All right. And is there a date as to when that was filed?
It looks like it was filed in 8/24 of 17.
Okay,
And there's also some additional paperwork before that, but I believe she went for her refund before that from the sheriff, but as we were told, that's not relevant here today.
not at the moment. Okay,
Right.
Yeah,
Thank
yeah,
you.
because they hitting me one by one. Demolition, tax, this also, so upset.
all right, so Mr. DiNatale, you've given us everything you want to give us right now?
I have submitted everything. I'm hoping you have the paperwork. You should. Yes, and basically that's the chronology. We know that it was purchased in February, the deed was recorded, and we know from just looking at the database that the property on April 5th, 2017 was designated unsafe. And before that, there are no other violations on the property. So as my client testified, she had no reason to think or know that anything was wrong with the property. And the property history is corroborated by her testimony and her experience at the sheriff. Also, what we have, in looking at what the city provided, it looks like notice was sent out the same day on April 5th, 2017, as when the property was designated imminently dangerous. All right, so notice was sent out. However, it was sent out to the former owner. It was not sent out to her. And again, if you look at the deed was already recorded in March. So there's absolutely no reason why notice should have been sent to the former owner. It's recorded in March, and again, that's evident on the sheriff's deed and also on L&I property history. You could pull that up and you could see all that on the OPA. I've looked at it all and it's verified.
So I actually have a few questions for the petitioner. Your home address is 3143 Long Stove Avenue, Philadelphia, PA?
Yeah, long short Avenue.
Okay, and so Melissa, the documents that the executive director, Andre, just sent around, are those the documents that the petitioner provided to you?
Petitioner. She is the petitioner.
I'm sorry, excuse me, Melissa, are these documents you just sent around, are those the materials the petitioner provided? Was that the stuff they, okay. So on these handwritten notes that you have here, you said the deed was recorded on 4/10/17, you just said March. So which date was the deed recorded according to your recollection?
3/17, March. The deed was recorded on 3/8/2017, and that is evident not only by the sheriff's deed with the little stamp recording, but if we look at the city of Philadelphia property records, which anybody can do at any time, it's on the OPA website under property.
I'm going to object to this documentation unless this documentation was pulled from 2017 when the actual deed
No,
was
it's a
recorded.
business record. It's a
Okay,
business
so
record.
my question is, there are handwritten notes on the materials that were provided to us as petitioners. I'm trying to figure out what is correct and what's wrong. So these handwritten notes are not correct. I should just
No,
disregard.
they're obviously not correct. I don't
Okay,
know where
okay,
they're
thank
from,
you.
but this is correct. The deed is correct. It's
Okay,
it's an
thank you.
official business record, and I'd ask that it be admitted as such.
Any other questions from board members?
Not at the moment for me.
Let's turn then to the city for any questions of the petitioner and any presentation from your witnesses.
Yes, may I proceed?
Yes.
Yes,
And I'm sorry, petitioner, if I mispronounced your name. So you stated that on direct that you purchased the property back in February 16, 2017, correct?
Yes,
And you purchased that sheriff's sale.
yes, yes,
So in other words, you purchased the property as is,
yes.
sight unseen?
Outside.
Outside, we don't see. We just,
We're not
we
allowed to go
bought,
inside.
but we bought, we went there.
Hold on. I just want to make sure if someone is asking a question that the person who was asked the question answers. So the gentleman in the room, just be very careful. I know you're jumping in and trying to help, but you know, it's a little confusing.
Well, can I object for a second? Because I am her son and we made this move together. Even though her name is on the deed, we made this move together and I was there on the purchase, sightseeing, everything.
Okay, it's just that the attorney was asking her and then you jumped in. So I just want to make sure that we keep that clear.
And I also want to make clear for the record that I will be objecting to any statement made by any other person other than the petitioner, as the son cannot testify as he is not the property owner or nor the petitioner regarding this matter.
Excuse me, they are allowed to bring other witnesses. So.
Understandable.
Hear him in, and her attorney believes that he has relevant information as a witness, then we will hear his testimony.
Understood. Now, you said that you did not get to see inside the property, correct?
Yes.
So you understood that by buying this property sheriff's sale, you took the property as the condition as it was in.
Yes. Mhm.
And you own that property in April 2017, correct?
Yeah.
And in May 2017,
Yes.
correct? You own that, and you still own that, well, the lot as of
Yes.
today. And you stated on direct that you had went to see the property at least 2 or 3 times.
Yes. Mhm.
Now, you went to visit this property in May of 2017?
I don't remember exact the day because I don't know what day is gonna be demolition or not. You know, because I was trying to bring the people. I don't know exact the day. I'm telling you 17. I don't know. But the time I went there, the house was like a demolition, and I went right away to sheriff's side.
But she's trying to say she was out there.
So hold on. Hold on. Wait. So let's clarify this out. Counsel for the city is going to cross-examine petitioner mom. Counsel for petitioner, I think you should probably do a direct for the son, so he can probably clean up some of this, and then the city subsequently can do a cross for him, just to make this easier for the record and everything else like that, so we can all follow. Is everybody comfortable with that course of action?
Yeah.
Okay.
Yes.
Fine.
So counsel for the city asks the question again. Petitioner, please only answer questions you know the answer to. If you don't know the answer, you don't know. Your counsel can then rehabilitate or work through your son if there's any type of gaps, okay?
Okay.
All right.
So petitioner, you stated that you went to see the property at least 2 or 3 times prior to you being notified it was demolished, correct?
Yes. Mhm.
And if I were to show you a picture of your property here today, would you recognize it?
Yes.
Board, permission to share my screen?
Yes. What, this?
Please bear with me. Technology is not my friend.
Sometimes takes a while to come up.
Can you see my screen?
Now it's coming up.
Mhm.
It's there now.
Okay. And petitioner, is this a fair and accurate depiction of your property when you bought it from sheriff's sale?
Yes.
Met dat portaal in toestaan?
Ja, acho que eu espia,
I'm going to stop. I'm going to stop.
Let them continue. I'll follow up with my questions.
And just briefly, looking at this picture, can you see this orange tag right here?
I see now. Yes, but it was not like that.
Okay.
I'm going to stop sharing my screen.
Before you do that, are you introducing that document?
Yes. Oh, I'm sorry. The city moves to have this exhibit, what has been previously marked as Exhibit B entered into evidence. My apologies.
And is there a date on that?
Yes, the date is marked May 4th, 2017.
Thank you.
Now, petitioner, you would agree that from the time you purchased the property up until the day of demolition, you made no improvements to the property.
No, I didn't do, no. And I told the reason, you know? I told the reason why not. Because it was the first purchase we done for my son. So that money we had it. So the time we go to bank to refinance the home to find the money, they take a little bit time. So we find the people first to clean the property. So we didn't know it wasn't dangerous. So we didn't, if I have a notice something, I was gonna rush. You know, but when you don't have it, so I didn't rush. You know, I said, oh, we planning to do with a company, to do with the private, to do, you know, different way, architect. So because it was like a 2,100 square feet.
So since you purchased this property back in February 16th, is it your testimony that you have never been inside your property at 5939 Chestnut Street?
Say again, after we bought the house, we went there because the door was locked. So we didn't know what is that. So when we see in the computer, just just in front. We didn't see nothing. We saw it was in a good position.
Let me clarify what she's trying to say, if I may.
Yes, you may. Go ahead. I'm sorry.
She's saying prior to the purchase of the sheriff's sale, we were only able to see it from outside. Once we purchased it, then we had access, the rights to move in and look. And that's when we took the lock out and we came in the property and we saw it inside, interior and everything.
It is your testimony today that you did see inside the property after you purchased the property on February 16, 2017.
Correct.
Board members, permission to share my screen?
Yes. Go ahead.
Can everyone see my screen?
Yes.
So at this time, board members, I am showing the petitioner what has been previously marked as cities exhibits Cities Exhibit C, D, E, and F. If this is too large, please let me know. I can bring it back a bit.
I'm sorry, I have a question. Do we have the right photographs? Because, I mean, the brick face doesn't even look the same to the adjoining buildings. Are we sure let's look at right. So we're looking at that, okay? I see two buildings on either side. The bricks are white. Well, on my left, on the other side, it looks perfectly pointed. And now we're looking at a picture where we see, we don't even see the front wall here. So do we have the right picture?
I'm going to object to any questions. You do have a right to, redirect your witnesses, and I would be happy to bring up these pictures. Thank you.
Ms. Davis, do you have any witnesses to verify these photos?
I do have a witness to verify these photos, Inspector Rabakowski. But at the moment, I just wanted to bring it to the witnesses' attention in terms of whether or not they had knowledge of these
I'm going to object to these questions until we find out whether these pictures are accurate. And not only that, who took these pictures? The person who took these pictures should be testifying and verifying their accuracy. I object to any further questions until we figure that out, because there's a question in my mind.
This is cross-examination, whether or not the witness was aware of these conditions. They can specifically state whether or not they were made aware of these conditions before the board.
The question though is, are these the conditions in her property?
Yes.
And how do we know that?
Well, the director.
I can save these questions for my witness. I'll be happy to save these questions for my witness.
But
I have a
just
question
for,
though, before we do that, Mr. Di Natale, for your petitioner. Can we go back to those pictures, Ms. Davis, for a second?
Yes.
Yeah.
The first picture with the orange sticker. Mr. Di Natale, can your client verify that that is the property that she recognizes as hers?
Let me,
An address on it? Is there an address on it, Ms. Davis?
well, there's a,
I cannot see the address on here, but the witness has, the petitioner has already testified that this in fact
That's
is
what
the
I'm-
property that
That's
she.
what I'm asking.
well,
Thank you.
listen, this is
he
about
verified that
getting
this
it
was the
right.
property.
This is about
She thought
getting
it
it
did not have
right.
to.
Wait,
This
one
is about-
person, I'm sorry, we can only talk
One
one.
at a
We're not
time.
gonna do that. We're not gonna talk over each other. We have a recording, we have a court reporter. Let's be respectful.
No, what I was saying is that to your question, Paula, the witness has already testified that this is her
Okay.
property, but when she saw the property did not have the orange sticker. That was what
Thank you.
his
I
testimony was.
missed that. Thank you.
Is
And
this
can
the
she
property?
testify as to the back of the property?
That's the property, okay. She does confirm this is what she purchased at sheriff's sale without the orange sticker.
Yeah.
She does.
I will reserve my questioning regarding exhibits C through G for my witness. I just have, may I proceed?
Yes.
Actually, I have no more questions for this witness. Thank you.
Okay. And you had two witnesses identified. Which witness are you asking?
I do. Could you state your name for the record, sir?
Aurelio Jeopardy.
Okay, and how are you at all involved in this?
Well, we went and saw the property. Me and my mother went together at the sheriff's sale. We did it on the property. We proceeded on pulling the loans under her name. I proceeded finding contractors and people to do the work. And
Okay,
as involved
All right.
with that.
so let me ask you this. You were at the property before you purchased it with your mother?
Outside,
Outside?
correct.
Okay. Does that picture that you were looking at accurately depict the property that you purchased, other than the orange sticker?
Correct.
Is that a yes? It's a yes. Okay. And would you have any reason to believe that that property was in danger of collapse by looking at that?
No.
Okay. Is there anything else you want to add?
It's just that it's questionable that orange sticker, the way it's pointed out right there with a white backing to it, it just seems to me, way too detailed to be within what's in next to everything else that has letters and everything else. To us, my recollection, me and my mother, we went and saw the property, we had never seen that sticker there.
Okay. Well, that's because that sticker, that's a picture of from May, not when you bought the property. You understand that, right?
Right, afterwards, right?
Okay.
But we went back and went into the property a couple times to discuss on how we were gonna move into it and what to do with it.
And the sticker wasn't there?
No.
Okay. That's fine. If that's your recollection, that's fine. I don't have anything else for this witness.
Back to the city then for your questions of your own witnesses.
Yes. So you stated that you went by to see this property about 2 or 3 times, correct?
Correct.
And you stated that you had, that at the time that you did go to 5939 Chestnut Street, you did not see this orange sign, correct?
No, because that would have put our attention.
So since May 4th, since prior to May 4th, you have not gone to see your property.
We went prior to it. We went the same day we purchased it, we went to it. A week later, we went to it, and we went again to it a couple of times. Can't say exactly 3 times, but a couple of times, maybe 4 or 5 times.
So you agree that if you had went to your property on May 4th, 2017, you would have seen this sign?
Was that on that day, May 4th exactly?
Maybe somebody took it off. You never know. Oh, raining, we never see. We went back. We
Right, I'm
went
sorry.
there.
But he's testifying.
Oh,
You gotta wait.
You can't jump in.
Yeah, he's the one testifying, so.
Do you need me to repeat the question?
Yes, please.
If you had saw this sign, so you agree that if you had saw this sign on May 4th, 2017, you would have, if you had went to your property at May 4th, 2017, you would have seen this sign.
I would have seen it and I would have done something about it.
No
I would
further
have talked
questions.
to somebody about it.
Thank you. No further questions.
City, are you ready to present your case?
Yes, I am.
Please proceed.
I would like to call Inspector Rabakowski.
Thank you.
May I proceed?
Yes, we've already said it 2 or 3 times. Please go ahead.
Inspector Rabakowski, can you please tell the board what you do for work?
Thomas Rybakowski, I'm assigned to the contractual services unit as a compliance construction supervisor. Prior to that, I was the building inspector and court liaison for the same unit
And how long have you been with license and inspection?
since 2014.
And can you tell us some of the duties, some of your duties in your capacity with license and inspection?
So my unit is assigned the tasks of inspecting properties and declaring them as either unsafe or eminently dangerous. And then we are assigned to either inspect the properties if the property is, or the owner obtains a make-safe permit for the repair of the unsafe or eminently dangerous property, or for the demolition and that demolition permit for that property.
Now, Inspector, are you familiar with the property at 5939 Chestnut Street?
Yes,
And how are you familiar with this property?
I'm familiar with the case record, as this is the, a couple times this has been for appeal of the demolition bill.
And can you tell the board why was this property demolished?
Property was declared as eminently dangerous due to structural defects of a property, and in the interest of public safety, the property was demolished.
Now, you stated that you did just state that you got a chance to review the record regarding this property. Were there any photos taken at 5939 Chestnut Street regarding its condition?
Yes,
And would you recognize those photos if I were to show you here today?
yes.
Permission to share my screen?
Please do.
Inspector, can you see my screen?
Yes.
So at the moment, board, I'm showing Inspector Rabakowski what has been previously marked as cities exhibits B, C, D, E, and F. Now, Mr. Rabakowski, were these photos taken during an inspection of 5939 Chestnut Street?
Specifically, these photographs were taken on May 4th, 2017, when the property was placed out to bid for demolition. These photographs were taken by the demolition coordinating team, and they would have been taken by Inspector Clark.
And are the taking of these photos conducted through the regular course of business regarding regular course of business for LNI?
Yes.
Board members, at this time, the city moves to have exhibits C through F admitted into evidence.
Okay, if we can
I
have a little
object.
more clarification of what those additional ones are. We earlier had clarification of the one with the orange sign as
Yes,
being the front of the building, but what are the angles or what is it we're looking at on those other pictures? And specifically, if there are differences in the brick face or anything else, how do we know that they're all part of the same building?
will do. Inspector Rabakowski, I'm showing you now what has been previously marked as city exhibit C. Can you tell the board what we're looking at right here?
So for Exhibit C, these are photographs taken of the rear of the property at 5939 Chestnut Street. The property at 5939 Chestnut is the property on the right-hand side. The property on the left is 5937.
And moving on to the next exhibit, can you also tell the board what we are looking at right here?
This is a photograph of the interior of the property at 5939 Chestnut Street.
Where?
Front or rear?
This photograph was taken from the rear of the property.
Okay, thank you.
Could you also explain what we're seeing here in Exhibit E?
This was another photograph taken of the property at 5939. It actually shows the overgrowth affecting the property.
And looking here at Exhibit F, can you explain to the board what we have here?
So this is another photograph of the property at 5939 Chestnut Street. It shows a tree growing out of the side load-bearing wall of this property at 5939 Chestnut Street. The property to the left, where the part of the photograph where the exhibit is marked Exhibit F, that is actually the neighboring property at 5937, which gives all the indications that that is an occupied property.
Thank you, Inspector. At this moment, the city moves to have Exhibits C through F enter into evidence.
Please note my objection.
Okay,
Now,
that's fine.
Inspector, I'm
Yeah,
sorry.
We've noted the objection.
Now, Inspector, looking at these photos, can you explain to the board the safety concerns regarding this property?
The safety concerns. So with Exhibit C, there are two photographs marked Exhibit C. You can see in the photograph to the top where it is date stamped or time stamped 957, that there are concerns with the exterior wall. You can see that the wall is actually bulged out. You can see vegetation growing off the wall itself. And then the other photograph that is taken that is marked Exhibit C, that is below this photograph, date stamped or time stamped at 958. That shows that the interior of the property does show that there is some structural issues. It shows that the interior ceilings have had are at a point of collapse, or that they have some structural concerns. You can see that the plaster has already fallen off of the ceiling, in that you can see the plaster and the lath exposed. And then the very last photograph in the rear of the property, you can see that a tree has taken root from the roof line all the way down through the property. It is actually pushing the brick assemblies out of that masonry wall.
And thank you, Inspector. And can you also briefly explain to the board under what circumstances or authority, if rather, does LNI have to demolish a property that has been deemed imminently dangerous?
So under the terms of a property being deemed eminently dangerous, the department gives the owner the ability to appeal the violation. If they do not appeal the violation, the notice posted to the property does speak that the owner has to obtain a permit immediately for the repair or the demolition of the property.
And you said in regards to the notice being placed on the property, was a notice placed on 5939 Chestnut Street regarding the conditions of this property?
Yes, following an inspection that took place on April 5th of 2017, this property was posted eminently dangerous.
And I'm now going to show you what has been previously marked as Exhibit H. Inspector, do you recognize this exhibit?
Yes.
What is it?
This is a copy of a notice, or this is a copy of a posting of an eminently dangerous structure. This is provided so that you can see that the notice indicates that a property, whatever that property address would be, in this case, it would have been 5939 Chestnut Street. It does speak that the owner must hereby ordered to repair or demolish the said structure immediately. You are also required to obtain all necessary permits for the repair or demolition. And then followed on the bottom of this notice that's posted to the property, you have the right to appeal this notice to the Board Administration Municipal Services Building, and then it lays out the address of where the administrative board is.
Board members, at this time, the city moves to have Exhibit H entered into evidence.
That's fine.
Now, just to be clear, Inspector, was this posting placed on the property at 5939 Chestnut Street?
So if you go to the exhibit that's marked Exhibit B, you can see that there is an orange posting to what would have been the front door of this property. You can see that these photographs were taken on May 4th, 2017. This posting, you can see that it is curled at the top and the bottom of the posting, indicating that it's been at that property for some time, in that it is weather beaten.
And typically, how long does a posting remain on the property? Does a posting remain on the property until the date of demolition, or is it removed prior?
So the department does not remove the posting. The department posts the property following the inspection when it occurs. This inspection, or the inspection that the property was declared eminently dangerous, took place on April 5th of 2017. That's when the property would have been posted by the area inspector. That inspector was Inspector D. Sabato. And then these photographs were taken when the property was placed out to bid.
Now, I want to talk a bit about the demolition process. I'm going to stop sharing my screen at the moment.
Before you can move on, could I ask a few questions just about what Mr. Rubikowski has already showed us? So Mr. Rubikowski, you testified that the property was inspected on April 4th, 2017, correct?
April 5th was when
April
the
5th, sorry, April 5th, you're right. And do the records show whether that is the first inspection for this property?
Yes.
And do you have any information as to what brought the inspectors to that property on that date?
Usually we have a call that comes in from either our 311 database or a complaint from a concerned citizen. If you give me a second, I could probably check the system and see if there was a call that came in. But generally, we either have a complaint from the general public. We could have the inspector doing an inspection of a property across the street in the alleyway of this property, and basically turn around and see that there's a tree growing out of this wall essentially and issue the violation accordingly. So we can issue the violations in multiple responses.
Okay, but that was the first inspection.
Correct.
Okay, thank you.
Please go ahead.
Inspector Rabakowski, can you explain to the board the procedure in which, what is the city's procedure when a property has been deemed imminently dangerous and the property owner has failed to take the necessary steps to cure those violations?
So typically what we will do is the property will be declared as eminently dangerous. Once the property is declared eminently dangerous, the property is posted and then notices are sent out to the recorded owner through our database. Once those notices are sent, we continue to monitor our system. In this case, the demolition coordinating team checked on or around May 4th of 2017. We looked in the system. We did not see a permit application for the repair of this property, nor an appeal in our system for the appeal against the violation. Essentially, there was no action taken by the owner, so the property was placed out to bid in the interest of public safety.
And when, after the bid was placed, well, when was, can you inform the board the exact date in which a bid was accepted regarding the demolition of this property?
The property was placed out to bid on May 4th, 2017. Under the demolition regulations, the bid would have been awarded the following day. So May 5th, 2017 was when that bid was awarded to the winning demolition contractor. Under those terms, we take the lowest bid.
And are those bids documented?
Yes.
And would you recognize a copy of that if I were to show you here today?
Yes.
Permission to share my screen?
Yes, go ahead.
Yeah. Okay.
Mr. Rabakowski, can you see my screen?
Yes.
Do you recognize Exhibit I?
Yes.
Can you explain to the board what this is?
So this is a printout of the bids that we accepted for this property at 5939 Chestnut Street. The department actually inquired or received 5 bids for the demolition of this property. They range from $15,800 all the way up to $64,440 for the demolition. As I previously stated, we took the lowest bid of $15,800.
Thank you. I'm going to stop sharing my screen. And Inspector, once the bid was placed and once the bid was accepted, at what point did at what point did the contractor rather begin demolition of the property?
Under the demolition, master demolition program, once the award is, once the contractor receives the awarded demolition, they can start the demolition within 2 hours of receiving that bid. So technically, if that bid is opened at 9 o'clock in the morning, they could essentially be there at 12 o'clock noon that day, starting the demolition. They have approximately 30 days from winning that bid to complete the demolition of that property.
And can you tell the board the date in which this demolition was completed?
I believe it was read into the record, but I don't have that date in front of me.
Would you recognize a photo of that area once it was demolished?
Yes.
I'm going to share my screen. At this time, I'm showing Inspector Rabakowski what has been previously marked as City's Exhibit G.
So this is a photograph taken by the area inspector the day the permit was final. That would have been July 28th of 2017. That's essentially when the demolition permit is closed and the permit is officially completed in our system. Now, that doesn't mean that the date actually matches that date, in that there could be a additional fiscal paperwork that needs to be completed for the invoice to be sent to the owner.
So, Mr. Rakowski, what are we looking at? Front to back to front?
So for the what you're looking at is essentially the front of the property. The inspector would be standing on the sidewalk. The property 37 would be to the right and 41 would be to the left.
And I'm looking at different bricks again.
You're looking at you wouldn't see the exposed brick because the adjoining walls were stucco.
Okay.
At this time, the city moves to have Exhibit G entered into evidence.
There's no my objection.
No, the city will accept it, but with the objection from the petitioner. I have a question for Mr. Rebekowski, if I may. Earlier in the testimony, there was an indication that see, I get this straight, so I get it out the right way. That notice had gone out to someone and that they hadn't responded or come back or entered an appeal. But I don't recall that you indicated who it was who was named to get that notice of imminent danger or any necessity to have the property identified as unsafe or ready to go to bid for demolition. Perhaps I missed the naming of the recipient or recipients of the notices, but if you didn't identify that, I'd like to know a little bit more about what happened or what you think was done from L&I's perspective.
So as far as the case record shows on this property, the case or the eminently dangerous case was written against the property on April 5th of 2017, and it was notice was sent out that day to the owner of record that was in L&I's database. That
Do you
owner,
know who that was, though? That's really my question, because I did write a note down that on 4/5/17 notice went out to the private owner, but no name was given that I recognized or wrote down. And I'm just wondering what your records show in terms of who may have received that notice. There could be more than one person or more than one identified recipient.
so I know through previous testimony that there was a deed that was recorded, or at least it was recorded with the Office of Records in March of 2017. Our database did not update, so the mailing was sent to the previous owner. The property was posted on November 5th of 2017. I mean, April 5th of 2017.
So
But did that list an owner's name?
I'm sorry,
Did that list a name of someone or just the property address?
just the property address.
So, and I have an additional question. In the city of Philadelphia, to make the type of repairs to the house, would it require a permit?
Yes, sir.
The average time to get a permit is what in the city of Philadelphia?
So under the terms, if a property is deemed as eminently dangerous, the property has, or a submittal has to be reviewed within 5 days. So if they went to the property on April 5th and saw the notice and applied for the permit, got a contractor and got a permit into our system, essentially it could be looked at.
I'm not asking April 5th. I'm saying when they testified that they went in there when they bought the property in February. So if they saw it, said we need repairs, if they would go through the normal course of business without it being an emergency in the city of Philadelphia, the average time to get permits is what?
So an average permit, if you're applying for an alteration permit on a property that's acquired, the review time is 30 days. But the permit is in our system, which gives us the opportunity to know that there is an ownership change, or at least a responsible party that we can contact. So if there was a permit that was in the system under review, the inspector would see that that permit would be there and reach out to either the contractor and say, hey, look, this property is worse than what you think it is. It's now been deemed eminently dangerous. You need to act. You need to get the essential documentation on this property.
And under the sheriff's cell laws in Philadelphia, how long is the right of redemption?
I don't know that right, sir.
So just for clarification, it's your testimony today that the individual that was actually noticed about this imminently dangerous status was not the petitioner that's here today testifying.
The mailing that went out by the department was sent to the previous owner, yes.
Okay. And absent the petitioner going by the property on April 5th of 2017, there's no way they would have known that the property was deemed imminently dangerous.
So being that there was no vacant property license or any other, but no, if they didn't go by the property, no, they wouldn't have seen the notice posted to the property.
Okay. And you're saying the demolition was completed by when on this property?
The demolition or the permit was officially closed in July of 2018.
Okay. And it was put
But
out.
the bid- but I'm going to
27.
interrupt. You also testified that the bid was let on May 4th and demolition
Okay.
began on the 5th.
Okay.
No, so technically speaking, under the master demolition program, they can, the property is placed for bid on, and in this case, May 4th. The bids are opened or released on May 5th. Under that term, they're typically opened at 9 o'clock in the morning. Under that program, once the contract is awarded to that demolition contractor, they can start the demolition within 3 hours of winning that bid. So
When did he
technically,
start?
they could be there at 12 o'clock that morning or that afternoon, starting the demolition.
Do
I
you know when it
technically,
started?
but when did they do it?
We had the same question.
Realistically, not technically.
I don't have the exact date.
You don't have the exact demolition date?
I don't have the exact date when they started. I do have notations from the area inspector that he was out on location and they had started the demolition, but I don't have that exact date in front of me.
And
What's
typically,
the date of that note? I'm going to wait. What's the date of the inspector's notice that he was out on site?
If you give me a second, I could look.
That would be great.
I have officially that the inspector was out on location on I have that the very first notation in the system is May 16th of 2017.
Thank you.
I have a question to you, sir. When you don't get a response back from the taxpayer within 30 days, what is the action city takes usually for this kind of cases?
For an eminently dangerous property, if we do not see something in the system in the way of an appeal filed or a permit under review, or at least something in our system showing that an owner is acting on the property, then we typically will place the property out to bid for demolition.
So you don't even make an effort to find this person or make a phone call or something like that, right?
If there's no vacant property license or no way to contact the owner in our system, the only way that we have in contacting the owner is posting the property and also sending out the notifications.
Okay.
Is there anything else that the city wants to add?
Yes, just briefly, Mr. Robertkowski, I just want to make this clear. Based on your knowledge, was this property vacant at the time of purchase on February 16, 2017?
Yes.
And did the petitioner file a vacant property license?
There is no vacant property license associated with this property.
And given the condition of the property, can you, based upon your years of experience, can you give an estimate as to how much time, regarding the condition of the property, based upon your experience with L&I, how long would it take for a property to get to the condition that it was in on April 4th when it was deemed imminently dangerous?
In looking at the rear of the property with the vegetation and the tree that's growing through the masonry wall, this would have taken some amount of time, a good significant amount of time for that tree to take root and cause that much structural damage to the masonry wall of the property.
And since the beginning of demolition, from May 5th up until July 28th, to your knowledge, did the petitioner reach out to the Department of License and Inspection?
Not that I'm aware of.
To your knowledge, did the petitioner arrive at the location of 5939 Chestnut Street?
There's no notes of an owner reaching out to anybody from the department.
And to your knowledge, from February 16, 2017 up until July 28, 2017, had the petitioner filed for any permits to cure the violations at the property?
I don't have any permits being filed for the repair of this property.
I have no further questions.
Okay.
May I?
I was just going to ask if there were any additional comments from the petitioner's side before the board steps aside to discuss what we've heard.
I would like to cross extensively on this testimony. I have many questions here. And I believe my clients have a right to hear the answers to them.
If you could keep them focused, that would be.
I will. Unfortunately, we had to go through the whole process of the demolition. That is not the issue here. The issue here is notice to my clients, which was tactfully evaded until one of the board
Mr.
members asked that question.
Mr. DiNatale, it
Now-
sounds like you're actually opining and not asking any
No,
questions.
I'm
So
getting
if
to the
you
point.
wish to ask a question to
But-
Mr. Robertkowski, please proceed so we
I
can.
am going to ask right now. Good day, sir. How are you? Good to see you again.
Nice to see you.
All right. So let's start with some questions regarding the pictures that you testified to. The pictures of May 4th, were you on site that day?
No,
Okay. Who took those pictures?
The ones on May 4th, when the property was placed out the bid, they would be taken by Inspector Clark.
Okay. How can you testify that those pictures accurately depict the site of 5939 Chestnut Street if you weren't on site, you didn't see Mr. Clark take those pictures? What are you basing your opinion on as the foundation?
Because they are uploaded to the case file for this property and assigned to this location.
Okay, so when somebody uploads the property,
Okay, so before, hold on, wait.
Yeah.
This is a business record. I think that we can go to that. I think the narrowing that we're talking about is the cross-examination regarding the inadequate notice that you're making as your
oh yeah,
primary.
but again, if this is public record, there needs to be a foundation. Again, there's no custodian, there's no testimony other than these pictures are uploaded, and we're not even getting to that because at this point now you cut me off, but it's public record, so that's fine. We can move on. Let me ask you a question about the notice, the orange sticker. Okay, so the orange sticker is placed on there presumptively to give notice to somebody, correct?
Yes.
Okay. Let's assume somebody sees that sticker. How many days do they have to take action before you can demolish the property?
The sticker says that they have 5 days to file an appeal and they must get a permit immediately for the repair or the demolition of the property.
So is it the case that after 5 days, you could theoretically demolish that property if you don't see any action being taken?
Yes.
Okay, so that would only give somebody 5 days, correct?
Correct.
Okay, now, in order to avoid that, and we've talked about this before, you guys do extensive research on the owner, correct?
If the owner has, if the information that we can get can be found, then yes, we will update and try to find that owner.
Okay, is there a reason why you sent a letter out, which I have, which was kindly provided to me before this, to Earl Grey on 4/5/17 saying the property is in imminently dangerous condition?
Because according to L&I's records, that was the recorded owner at that time.
Okay, and what search does L&I conduct to determine this?
We can conduct it in 2 ways. We go through our database, which is uploaded by the OPA or the Office of Property Assessment. We also look at the recorded deeds.
Okay, and in this case, if the deed, which it was recorded a month ago, shouldn't it come up on your database?
It might have said that it was recorded at that time, but it might not be updated to the official Philadocs website.
Okay. Now, we also just had another case, and we had the same discussion. Correct me if I'm wrong. You also checked the sheriff's sales. Isn't that right?
If we know that the property was sold, but we don't have a record of it being sold.
Okay, so there was no record in this case of the property being sold?
If we know that the property is sold at sheriff's sale, in the case that you're referencing,
yes.
The owner actually came into the property at the time we placed it out to bid.
Hold on, we're not going to do that. We're not talking about ancillary cases in regards to this case. That's enough. So, thank you.
You also mentioned, sir, that the purpose of the letter is, and I wrote this down, gives the owner the ability to appeal the violation. But if the owner never gets that letter, they can't appeal, correct?
So does the posting of the property.
The posting of the property, okay. All right. Now, you've been doing your job for quite some time. There's a couple different programs that you operate under, right? So my question is, you demolish properties when they're imminently dangerous, right?
No, we demolish properties if they're deemed eminently dangerous or unsafe.
Okay, is there also another license and inspections demolition program that the properties are demolished under?
No.
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 Okay, so why would this say for the complete demo of a vacant property as part of the City of Philadelphia license and inspections demolition property?
Demolition
program.
So that is the demolition program. That is the master demolition program that I was referencing.
Okay, and if you go online and you type in City of Philadelphia demolition program, would you agree or disagree with me that actually there's a whole program there from L&I and it lists all the properties that are slated for demolition?
No, that would be a eminently dangerous case that is not the master demolition program. That is actually a list of properties that someone put together some time ago for different violations for properties in the city. The master demolition program is just that, is the requirements for the master demolition program the city follows.
Okay, so there's two different types, and sometimes you'll agree that.
To object to this line of questioning as to relevance.
And so you will agree that it's sometimes posted on the internet, sir?
I'm not sure. A lot of stuff is posted on the internet.
Objection to relevance to this line of questioning.
It goes to notice. If what I'm trying to get at to see if anything was posted on the internet as an extra notice.
And just ask that. Just ask that.
So do you also post on the internet or no? When properties are going to be demolished?
No.
You don't? Okay. So the letter that was provided to me, do you agree or disagree that your department sent that letter out?
Yes.
Yes, you did send it out?
Yes.
Having heard no response, which I assume occurred, were there any other measures taken in this case?
No.
Okay. Also, there's a photo of 7/28/17 that was shown to you, and there was some question about whether or not that was the final product. Well, let's back up. Were you out there on 7/28 when that photo was taken?
No.
Was it taken by you?
No.
Okay, who was it taken by?
By Inspector DiSabato.
Okay. What was that picture intended to depict?
That picture is to close out the permit that the demolition is complete of the said property.
Okay, so is it possible that the demolition was not completed on that day, and in fact, it was completed perhaps weeks prior to that, but that is the final picture of maybe when the walls were stuccoed, the final product? Is that a possibility?
Yes.
Okay, and looking at your bill from the demolition company, can you tell me when the demolition was actually took place?
When the demolition took place?
Yes.
So the first inspection on this property took place on May 19th.
I think
When you
this
say the
line,
first-
I think this was
We
all
went
asked
over
and
that, or at
answered.
least some of that before.
When you say the first inspection, what does that mean?
That means when the demolition contractor is out on location by the inspector.
Okay, very good. But there were obviously inspectors prior to that determining that the property was unsafe, right?
The inspection that declared the property as eminently dangerous took place on April 5th.
Okay. Now, do you recall the picture that was taken on May 4th of the front of the property with the orange sticker on it, sir?
Yes.
Okay. You recall seeing the picture of the white brick, right?
Yes.
Okay. Using your recollection, you as an experienced inspector, could you tell me what would signify to you that that property is in danger of imminent collapse at that point? Just by looking at the outside the way we all just did on that picture.
Well, from the front?
Correct.
Well, from the front is not, if you're just looking at the front of the property, that's not a complete inspection. You have to inspect both, the entire property. So if you're looking at the property, then you would have to look at the rear as well.
So my question is, if a lay person such as my client were to walk by that property, as she testified several times, and there's no orange sticker, by looking at it, is there anything to give away that, hey, maybe I better hurry up and do something to this property?
If I was purchasing the property, I'd look at the whole thing, not just the front wall.
Okay, my question to you is there anything on that front wall? Any bulging wall, any bricks falling off? I mean, from when I looked, it looked pretty good. It looked pretty secure, pretty tight. It was even boarded up. It looked like somebody took the time to board it up.
To object, is there a question being asked here?
That is my question. Is there anything there that would signify to my client that building?
We've been there already on this. Is there something new that you need to ask, or if not, the board?
I would just like to know the answer from the expert. It's a yes or no question. Yes, there is, or no, there's not.
I thought it had been answered 2 or 3 times, but
Ms. Surdakowski, yes or no?
The front of the property, it doesn't look like it's the area of concern on this location.
Thank you.
Okay, thank you. I have nothing further.
I have a question, if possible.
If they let you, go for it.
No, you have counsel for a reason. We are going to go back. Thank you. To
Counsel to ask him,
What's your question?
here's my question, is that his experience, based by his experience, he decided to put the property into demolition. Now, on his testimony, he said that the vines and the tree was growing into the brick point in the back. Because of that, you stated that the building was an imminent building.
Is there a question being
Yeah.
asked?
Now, I'm sure City of Philadelphia has many programs where they would take care of that issue instead of deciding to demo. What did you do to file for the tree removal or the vinyl removal? Since City of Philadelphia has the eclipse.
I'm going to object. At this time, this is now testimony.
it is.
I would say we're going off on a tangent. I don't know. that
That's
there's
fine.
anything
That's
here
fine.
that
So
we
they're
need
not
to
gonna,
discuss in this.
they're saying it's not relevant, okay?
Thank you.
Saying
I
it's
think-
not
I
relevant.
think-
Let's, at this time, the board is going to the back. Everyone stay put.
May I get an opportunity to redirect Inspector Rabakowski?
I think we've covered as much as we want to hear at this point, and there may be other questions after we discuss it. I think we'd like to step aside and see where we are right now.
Everyone just stay there.
So are we muted right now?
No, I don't have mine.
I wanted to ask you more questions.
They want to get the decision. We can always appeal, but we got to do it, but right now, let them make their decision. It's pretty obvious that notice was never sent to her, so that's that. I mean, a month later, still isn't in the system, come on,
In front of the house, how
pretty obvious.
if you go regular house, you can find some,
It's,
yeah,
look, it is what it is, it's,
yeah.
you know, that's why they didn't even bring that up on direct. They just said, oh, was it demolished? Well, of course it was demolished, but the issue is, was there notice to you? So we know.
And I remember the guy, he took now, he spoke from license.
Mhm.
I was there after the demolition. He said, okay, go, because he is, you have just making out this day, is the day I recognize. I say, you are on time, go complain because they went to the
I mean, they went above, started 2 buildings, so they couldn't start with a brick wall. They couldn't put nothing together.
It's crazy.
They cleaned the trees.
Yeah.
Well, because they're demo, they clean the trees anyways.
Well, once they see that, they just say it's dangerous and we're gonna take it down. But they're not gonna cut the tree out of the wall.
But they have the system, well, not the wall, but they stop with, right? They stop with the 2 buildings, and they stop with the brick walls.
Wow. It's not even about what they did.
Yeah.
Did you get notice? That's the only issue. Did you get notice? You didn't get notice. It's clear.
My thing is
I
here,
mean,
my thing is here, his decision, by his lack of experience, his decision cost a bill of $18,000. So he should be responsible for the bill of $18,000 if he causes a decision. Now, there's other programs out there that the building offers
I understand.
to fix the issues.
I
But he
understand.
decided to do a demo instead of fixing that.
Well, listen, I know for a fact, they do sheriff sale searches. They look at all this stuff beforehand, okay? So I don't know the reason why a month later, the deed isn't showing up on the system. But there's no excuse for it.
Right.
If the deed isn't showing up, it's a problem with the city. It's not your problem.
He stated 2014, he started working on it. 3 years experience, 3 years experience.
Oh, listen, I've done 100 of these cases. I know, listen, it is what it is, you know? So, I mean, it's clear what happened. They don't have notice to her. That's it. It's clear. Now, what they're gonna say is you should have saw the sticker, which gives you 5 days, but you don't even know because, listen, that's Chestnut Street. Somebody could rip that sticker off. A million things can happen. I mean, and even if you saw it, you have 5 days to do something. After 5 days, they can demolish it. And it happens all the time. You know, you're not the first one, so.
How they find the address to send the bill after?
Well, because
Yeah.
you're paying your taxes. It's in the system.
Yeah, but before they didn't find me.
Happens all the time. Nothing new.
Before the demolish, they don't find the name. After they bring the bill.
Right.
Then they find the
And we
name.
went through an hour testimony about pictures. Was it demolished? When the only issue is, did you get it? Did you get notice? And really, you didn't get, we saw the notice, right? So the only argument is, well, you should have saw the yellow sticker or the orange sticker. Well, why should you have seen it? There's nothing on that building from the front to indicate that you should know something. Now, I guess you're supposed to go in the back. You're supposed to hang off the, I don't know, but hey, listen, I'm walking by there. That building looks fine to me. You know, now if I see a yellow sticker or something, that's different, but who knows, you know, you were there, you had no reason to think anything, you know? I mean, I could see maybe if the building is falling apart, you kind of look and go, all right, yeah, but that building, it was even sealed, which is amazing.
I know.
Because most of them aren't even sealed, and so you look and you go, oh, wow, the windows are open, I gotta see.
That's why we saw on computer and they look good.
That building looked good. I mean, I would have never, you know, when I saw the pictures, I was like, is this the same building? Because the front looks beautiful. Like, you know, who knows that the back looks like that? I mean, you know, I don't know. But yeah, I mean, it's like that. Then now you're paying $37,000. You're paying taxes. It adds insult to injury because now you're paying taxes on a building that's been demolished, right? And now you got to pay for the demolition.
And the house, 60 cars and something. And then we have been trying to sell it. Nobody bought it.
Well, of course not.
It's not a good
You know,
position.
yeah. You're like I said, you're paying $2,900 in taxes because you're still being assessed that it's a building. How? All right, does that make sense to you? You tell me how that happens when they're reassessing every building in the city. Yours is still, you know, it's a building on there. I mean, it is crazy when you think about it, but I mean, things happen. It slips through the cracks, but you know, I don't know. Beats me.
Hold on, I'm just waiting.
I know. Make sure they're all back.
Just Paula.
Paula and I have been.
Yes, okay.
Routine left out. Okay, I think we're all back now. The board, after discussion, has reached a decision. It's our decision to abate the entire bill. We are basically siding in favor of the petitioner. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of our letter. Assuming for the moment that neither side's going to choose to appeal to court, then at the end of that 30-day period, the city should move to abate the bills against the petitioner.
Does the board concur?
Oh, yes, we need to verify for the record that the board concurred. So if we could poll the board members, Ryan?
Ryan Boyd concurs.
Dominique Ward concurs.
Paula Weiss concurs.
George Matthews concurs.
Nancy Cameriner concurs. We thank you all for coming together on this today. And you'll get that letter from us relatively soon. It does take a little longer these days with the mail and all, but you should be hearing from us within a couple of weeks with the decision of the board.
Thank you.
Thank you. Have a great day.
Yes, both sides have the right to appeal to the Court of Common Pleas. Yeah.
Just making sure I didn't hear it.
Yes.
Thank
All
you.
right.
That concludes my business. May I be excused?
Yes, you may.
Thank you.
Thank you.
Let's see, what do we have left?
Cases 1 and 6.
Okay, and those are for Alfred Izakaj. I'm not sure if I'm pronouncing
Yeah,
that
now my
correctly.
camera's.
Okay, and it's docket numbers ending in 8874 and 9256 for property at 20 South Ruby Street. I think we have some people here for this matter.
We actually reached a settlement agreement in this case.
Wonderful.
Okay, please identify yourself for the record right now.
Sure. Good afternoon. Catherine Holland for the City of Philadelphia.
Thank you. And do we have anyone from the petitioner who's with us that we need to
Yes,
identify? Or
good afternoon. It's
I see there is someone here who's just identifying himself. Please.
Good afternoon. It's Kornfeld on behalf of the petitioner, Alfred Isakai, I think it's pronounced.
Okay, thank you. And you're representing him in what capacity?
As his attorney.
As his attorney. Okay, I didn't know whether you were an attorney or not. You come up with your name identified with PhD. and so I wasn't sure.
For petitioner, I will identify myself. For petitioner, Itzhak E. Kornfeld, that is spelled I as in iron, T as in tango, Z as in zebra, C as in Charlie, H as in hero, A as in alpha, K as in kilo, E, middle initial E, that's E as in echo, sir or last name, Kornfeld, spelled K as in kilo, O as in Oscar, R as in Roger, N as in nitro, F as in foxtrot, E as in echo, L as in lime, and D as in delivery.
Okay, thank you very much. The city's council had indicated that you had reached some sort of conclusion. If one or both of you could give the board a capsule summary of where it stands and whether or not there's anything this board needs to do, or just where you are in your settlement.
Yes, we discussed this late yesterday evening and have come to an agreement for the defendant to pay $13,800 over 2 installments that will be completed before July 7th, 2022. I am working on the settlement paperwork as we speak, and we'll be sending that out, and we'll have that over to Ms. Andre in just a few, if not today, probably tomorrow or Tuesday.
Okay, so basically we should continue this matter for that settlement to be finalized, and that we will be notified of the completion of the agreement and the fact that at that point it should be withdrawn from this board. Is that correct?
That is accurate, yes.
And we should hear from both parties, both the city and
that is correct.
And
This is it's Kornfeld. That is correct.
Mr. Kornfeld, when you get an opportunity, once the settlement has been reached and signed, can you just send me a withdrawal notice, and that way we will withdraw this case and send you that paperwork?
Pardon me, via fax?
Fax is fine, mail is fine, email is even better.
Well, if you
as long as it's a written response, that's what we need for our record.
Do you need my email address, Mr.
Ms.
Kornfeld?
Andre, I'll CC him on the settlement letter, so he'll
be
see.
most helpful.
Mr. Kornfield, I'll ensure that you get that email address when I CC you, and I send the settlement document to her.
Okay, all right.
That's great.
Oh, that's good.
And we appreciate your patience this afternoon. Had we realized this, I think we might have changed the order of our activities there, but we appreciate that you stayed with us and were able to give us this information. Are there any other items to come before the board that I am not aware of?
I just need the board to concur on the decision to continue this matter.
Yes.
Ryan Boyer, I concur.
Paula Weiss, I concur.
George Matthews, I concur.
And George, okay.
I concur.
Okay, and Nancy Camerodiner. So we've all concurred on that last one, and we appreciate everyone's participation today. And I believe that being the last item on our agenda, this hearing is adjourned.
Thank you,
Have a good
everyone.
Thank you.
Thank
Colin,
you.
next time this happens, just shoot me an email and I'll make
He
sure.
did. He sent a letter to you guys, I thought
I
already.
sent,
So
I
that's
sent
why
you I faxed you a letter this morning at 9:46.
I'm sorry I missed it.
That's okay. That's why I thought you knew. I apologize, but I thought you
apologize.
had his letter.
Yeah.
And I didn't know, I'm still new. I didn't want to interrupt you guys.
Oh, you're not. You could always shoot me an email and I would have stopped the other hearing and been, wait a minute, let's do this one first, okay?
A life lesson.
Yep.
Thank you for telling us about the shortcut.
No problem. Have a good one, everyone.
For future reference.
For future reference.
you,
Thank
everyone.
you.
Have a good day.
With
Okay,
your
thank you all.
permission,
Have a good weekend.
I will get off, and I wish you all a lovely, at this point, late afternoon and evening, and a wonderful Friday and a great weekend.
Thank
Okay,
you.
thank you.
Same to you.
Thank you.
Bye, everybody.
Bye.
Bye-bye.
Bye-bye.
Ms. Nagel, are you
Thank
good?
you.
Yes, she's good. And yes, Richard, I was very, very happy when I heard it.
Can we get a copy of the hearing sent to NBC for the new legal drama that Mr. Natali is auditioning for? It's a 2-hour drama, just to let you know.
Oh my gosh, I tell you, every time though, now it's like a thing he does. It's like his thing, his shtick. Oh, the whole
All
time.
right, have a great Memorial Day.
You too, Rich. Bye.
See ya.
Bye-bye.